that's those two things, yeah. Next, we're opening up the hearing on Senate Bill 430. And the prime sponsor, I believe, is Senator Lang.
I did text him.
He's coming, okay.
Thank you. This actually goes with the last recordings of the steps and changes. And puts out the decision. And I apologize. I was actually here on time, but someone insists on parking in my parking spot every day. Today was Representative Spillane. So I had to wait for cars to be moved
Talk to the
every day.
parking, waiting for Senator Lang.
I have a difficult time fitting in my space. It takes me about a good 7 minutes to get in.
You have a big
So I was here actually, I arrived at the park by 9:05. And I walk in at 9:09.
Using my state, the LOP,
Yeah.
because the parking garage used the entire street.
I did that yesterday.
So I did not.
Thank you, Madam Chair. I am Senator Tim Lang. I am here as the prime sponsor of Senate Bill 430. And while I know yesterday was Groundhog Day, I think it feels like it's probably again today. You have before you at Senate Bill 430, again, the Honesty and Transparency in Education Act. This is, again, a process bill that requires if a parent, sorry, I'm out of breath, I ran all the way over here, so you didn't have to wait for me. So, again, this is just makes clear that when a parent makes a request for information to the school or teacher, that there is an obligation to respond, and there's a timeline around the response. It's as simple as that. Again, a process bill that just says, teacher asks something, a parent asks something, the teacher has to respond in a timely fashion and do it with honesty and truthfulness, not hide or lie. I don't think that's an unreasonable concept. I ask you to pass the bill.
Questions from the committee members? Senator Altshuler?
I'm okay. I'm okay. I don't have a heart issue, so I'm good. Right now, my watch is telling me I'm okay.
Thank you, Madam Chair. Thank you for taking my question. So this bill allows, if I read this correctly, if a parent wants to seek information about their child that they don't feel they're able to get that information directly from their child, they can then go to the teacher and they have to ask in writing a specific question. And then the teacher has to respond in 10 business days. What's to impede a parent from sending a daily question?
I'm sorry, from sending what?
What's to impede a parent or a group of organized parents from submitting daily questions to a particular teacher to bury them in paperwork? So this is something that we've seen in our schools for right to know requests. So this is seems like a form of a right to know request that without any parameters on it, because it's really not a right to know request. It's just another way of extracting information that may or may not be satisfactory. How do we stop this from being a 180-day process?
So thank you for the question. First off, again, the right to know is a good law. It creates transparency in our public school systems, and nothing we do here is going to stop somebody from abusing the system. Or very little we can do here to stop from abusing once we allow a thing like transparency. But in this case, again, we're talking about a child, right? And if the argument is made that the teacher is a trusted adult, that's probably one of the most trusted adults, second only to the parents. So they're most likely to have the best information about the child besides the parents. And so I don't think we should limit when a parent asks a question. There's probably a cause or a reason behind it. And the teacher shouldn't make any assumptions, but just answer the question honestly.
Can I follow up?
Follow up.
Is there, like, are you suggesting a particular way so that it's uniform? So the response from this legislation would be a uniform response from every public school teacher, because I don't believe this also applies to voucher kids, right? So if there's a prescribed way that the teachers must respond, is there a prescribed way that the parents must ask? Are you looking for a form? Can it be a one-line email? Does it have to be on paper? Like, why is there not a way for the parents to ask that mirrors how the teachers must respond, so that there's some equality in there?
Sure. If you can make an exhaustive list of every issue with the teenager, I'll be happy to take that exhaustive list, but there isn't one, right? I've raised 4 children, and all of them are unique, and all of them are different. All of them had different issues. So the ability to create a form that would encompass all of those things that happened would be next to impossible. The question, I think the answer to your question is yes. The request must be in the form of a question, kind of like Jeopardy.
May I follow up, Madam Chair?
Follow
That
up.
wasn't actually my question. So my question, I also, like you, am a parent and have 3 very, very different children who were wildly different from all of their peers. This legislation, though, and we're talking about this legislation and not our own individual experiences, which I understand inform our responses to this. This is requiring every teacher who has anywhere from 10 students that they work with. Some special education teachers have 5, all the way to high school teachers who have multiple classes that they manage and can have, some of them, up to 60 kids on their roster. So there's no differentiation between the number of kids that a teacher teaches and how quickly they must respond to a written request. And there's also, what I'm looking for is, since the parents are also as varied in their request, is there going to be a uniform way in which the parents must make this request?
I think I answered that question. It has to be a question. I don't know that there's a form you could create that would encapsulate every possible scenario, and therefore they would write a letter to the teacher and write, again, in writing, and ask a question. I would like to know whatever the question is. And again, that question can't be uniform because not every child is uniform, right? And so I don't know that you can generate it. And again, I just make the statement that teachers are probably the second most trusted adult and therefore have a responsibility as well. And you can't ignore that responsibility. If the responsibility is they know about the child and they're working with the parent, they should be happily engaging in these questions and not pushing back against them.
May I follow up?
One more.
Thank you. So we've seen an advocacy group within the state of New Hampshire launch social media and print campaigns encouraging parents to launch FOIA requests and complaints about their school board. And if you're not sure how to do it, we'll give you a format. And the intention is to bury the school board in requests. And I'm not extrapolating that. That's what they're putting in their social media. So does this not set up another situation where an advocacy group who, has a particular issue can then use their membership to bury a certain teacher or a department in innumerable requests day after day after day, so that it essentially hampers the teacher's ability to do their job?
I think what you're describing is civic engagement, and I support civic engagement.
Senator Sullivan.
Thank you, Madam Chair. Thank you for taking my question. Do you anticipate parents using this judiciously and only when they have a concern about the health and well-being of their child?
Absolutely. And I've made this statement before, having raised 4 kids. In every parental relationship, there's an ebb and flow to that relationship. I've had my children love me, and I've had my children be really angry with me, right? And depending on where you are in that ebb and flow is how well you engage with your child, right? And so the idea behind this bill is that you may be on the ebb side, where your relationship's not necessarily that great with your teenage daughter or your teenage son or whatever's going on, and you know something is going on, and you're concerned as a parent. So where do you turn? To the next, second most trusted adult, to the teacher, and say, hey, is anything happening with my child that you're aware of, right? Imagine the idea that you knew something was going on and you didn't respond, and then that child hurt themselves. Children, when they commit self-harm, don't do it at school. They do it at home. So if the home is not informed of what's going on when there is something happening that's known to the second most trusted adult, is there any liability that now swings onto that second most trusted adult because the child did commit self-harm and the teacher or that second most trusted adult knew there was something happening in that child's life, was explicitly asked by the parent, and then wasn't told? So again, I think that this is all about what's best for a child. And again, parents know what's best for their child, and to helping them be most informed of what's going on with their child is only in the best interest of the child.
Follow-up? Thank you. Would you believe that the scenario that you just described happens to a family in Manchester where the parents were very engaged with their child and went to the school because they knew something was wrong, and they were not given the correct information and the child was harming themselves?
So again, the goal of this bill is to make sure that never happens again.
Thank you very much.
Any other questions? Seeing none, thank you very much.
Thank you, Madam Chair.
Now we have David Trumbull.
Good morning. Thank you, Madam Chair and committee members. My name is David Trumbull. I'm from the town of Ware. Thank you for the opportunity to testify. I oppose this bill for 3 reasons. First is that children have a right to privacy and the right to make choices about their own lives. By the time children are in their teenage years, their thoughts and views about their own lives are important and must be considered. This bill creates a paradigm where the only actors involved in this decision are the parents and the school. And the bill gives 100% of the rights to the parents, 0% to the school, and 0% to the children. Children should have the right to talk with trusted adults, such as teachers, about personal matters. I urge you to look at the text of the bill. Where in this bill is the right of a child to have any input in this decision? It is not there. They are left out of this bill. Even if you look at something like divorce proceedings, by the time children are 13 or 14 years old, their input is given great weight by the courts. That is just goes with common sense. If you raise children, by the time they're teenagers, they have well thought out opinions. They have some rights. They don't have the final right. I'm not saying they should get 100% of the right, but they should be factored into it. And this bill, I ask you, look in here. Where is the child's right to have any input into this decision? And it's not there. I'm going to go out on a limb here and try a farmer analogy. I hope it works. If you've done anything with soil, you'll know that there's a soil triangle. you send in a soil sample. There's sand, clay, and loam. And you send in your soil sample, and it'll be located somewhere in that triangle. If you sent in 100% sand, it would be at this point of the triangle, 100% clay there, 100% loam there. In this equation, it's the parents, the child, and the school. This bill says that it's 100% for the parent. The child has 0% interest in this decision, and that leaves the child's rights out of it. Second is that the parents' rights should be balanced with those of their children. The New Hampshire Supreme Court in Doe versus Manchester said that while the parents' right to raise their child extends to the public school setting, it is not an unqualified right. Right there, it's not 100% and they based that on the New Hampshire Constitution. The New Hampshire Supreme Court also said that a school policy that does not force staff or teachers to reveal a student's LGBTQ status to the parents, quote, places no limits on that parent's ability to parent her child as she sees fit. And the court concluded that parents have self-help remedies, including talking with their own children. That's part of the obligation and responsibility of being a parent, is to talk to your own children. This bill pretends that parents don't have an obligation to start these conversations and actually listen to their children. Instead, they will go straight to a teacher. And the third problem with this bill is that the exception provision could damage family relationships between the parent and the child and may not be consistent with existing child abuse and neglect law. The bill requires that a school either tell all to a parent or file an abuse or neglect petition with HHS. A school may not have evidence of past abuse and neglect, but may have good reason to believe that a child who is coming out might be thrown out of their home if the school reveals everything the child has told them in confidence. It's not clear if this falls within the current abuse and neglect statutes, which do not include the words potential abuse. Nonetheless, if the school files that petition, the accusation will be investigated. The filing of the petition could cause long-term damage to a parent-child relationship that needs help, patience, and communication. Sometimes giving things more time is a better solution than either a child being thrown out of their home or a legal proceeding which will investigate a parent and then damaging the long-term relationship. This bill forces the issue when sometimes that is not the best thing. Children have some wisdom, they have some rights, they're being completely left out of this decision. This bill goes too far. Thank you.
Questions from the committee members? Seeing none, thank you very much.
Thank you.
Amir, I am not going to try the last name. Is that you? Please come up. I can get the first couple of letters, but then the end part of is totally lost on me.
My parents wanted almost every letter of the alphabet in there, so. Good morning. My name is Amy Teravecchia. I am with 603 Equality, and I am here to oppose SB 430. My opinion today is informed both as an advocate and as a mother, and I have several concerns with the bill that I'd like to outline. So I'm going to echo some of the things that some of the other folks have said already, but educators and educational institutions should not be a pathway for parents, in my opinion, to learn more about their child's identity. This creates a concerning and, in my opinion, even dangerous precedent for placing public schools in a role of surveillance. Schools should be a place of learning, an environment of study for both curriculum and a place of critical self-examination. Placing educators into a role of monitoring and reporting removes trust necessary for a thriving academic environment. SB 430, if signed, would also be detrimental to building trust between child and parent, as others have pointed out. It removes the opportunity for parents and children to build trust within their own relationships by having open and honest conversations. There's been ample research that shows that children who have big or difficult news to share with parents tend to have better long-term outcomes when provided with opportunities for them to share that information with parents directly. And although SB 430 references RSA 169C30 in order to grant protections and safety to children at the center of these requests, risk inside the home is often really difficult to ascertain for educators. And when put at odds with the threat of investigation and punishment an educator may face for failing to comply, it would again put educators in a role of detective and the public school system in the role of surveillance in order to adequately comply with SB 430 and also balance the safety of their students. It is for these reasons that I urge you to recommend this bill inexpedient to legislate.
Thank you. Questions from committee members? Seeing none, thank you very much. Senator Altshuler.
Thank you, Madam Chair. And Ms.
Tara Vecchia.
Tara, I'm sorry.
No, it's quite all right.
Vecchia, thank you. Tara Vecchia, for taking my question. I appreciate that. So right now, all adults, anyone over the age of 18 in New Hampshire, which would include all teachers, are mandatory reporters if they are aware of a child that is currently being abused, sexually assaulted, in danger, neglected. They are required to give that information. However, I think you mentioned in this bill, and you referenced Part 2, lines 10 through 14, that that now teachers only outside of the scope of mandatory reporting now need to make a good faith determination, according to the legislation here, if there's potential or if the student would be at imminent risk of physical harm. So in a scenario like you described with the LGBTQ adolescent community, if an LGBTQ student was not ready or felt uncomfortable or perceived danger in being honest and open about their sexuality with their parents, but wanted to speak with a credentialed educator. So could be the, physical education teacher, could be their art teacher, could be their theater teacher, could be any number of people, not necessarily, your APUSH teacher. That teacher is now in the position of having to determine risk factors outside of the scope of 169C. And so doesn't that put the teacher at risk of possibly putting their student at risk?
Yes, I think it creates a really impossible situation. A lot of times an educator can't possibly understand what's going on outside of the classroom, going on in a student's home, and putting them in a situation where they have to try and determine the risk level of that student without maybe having all of the facts or information to weigh the student's safety, but also understand that they could face serious professional consequences too for not complying to this. I grew up, to share a personal story, I grew up with a classmate who was once told by their parents were upstanding citizens within the community, no signs of abuse or neglect, but they were once told by one of their parents that they would rather have a dead child than a gay child. And there was no possible way for the educators in our school system to know that that was a sentiment that their parent had. Had this bill been enacted and that educator disclosed to their parent, they would have been put in imminent physical harm within their home life. But there is no way for that educator to know that in that scenario. So to put a real world, story and context to the impact that a bill like this could have on a young person's life, it is, potential homelessness. It is potentially being put at risk, but it's very serious threat for some young people as well, unfortunately.
May I follow up, Madam Chair?
Follow up.
So we heard from Senator Lang when he introduced the bill that if teachers don't respond in writing within this 10 days, then in his words, they could, have contributed to the suicide of a child. Is that a fair accusation to put on a teacher that
I mean, as you pointed out, educators and all adults in the state are already mandatory reporters. And I think that educators are always on the lookout for the mental health and well-being of their students. There are resources at both the school level, but there's also already things in place within the community system and within the school system for educators to contact parents if they think that there is a risk that maybe isn't at that elevated level yet. But I highly doubt that there is any educator that would knowingly or willingly withhold information that they believe would put a student at any risk. To answer your question.
Thank you.
Any other questions? Thank you very much.
Thank you.
Brian Hawkins.
Thank you, Madam Chair. For the record, Brian Hawkins representing NEA New Hampshire. We are here opposed to this bill because first we think it's unnecessary and could create further confusion. So first, let me just say that in most, if nearly all cases, there are a lot of tremendous relationships that parents and educators have throughout the state. I think it's worth lifting that up and talking about that, because I think that sometimes gets lost in the discussion that we're having around some of these bills. But what I wanted to point out is there was a bill passed, I'm sure you're aware of, House Bill 10 last year, that talks about the right that a parent has to make inquiry of school and school personnel. And that is different than what is, there are similarities, but it is different than what is enumerated in Senate Bill 430s. So one question we would have is, what is the difference that 430 does versus HB 10? There is a difference in some of the writing around the 10 days, the business days. There's in HB 10 they talk about when there's an initial request made, some leeway around if immediate answer cannot be provided. There's also the standard around completely and honestly, which has come up, I think every year this bill has come in. I think there was testimony a couple of years ago around the fact that completely and honestly is a standard used not that often, that it's often bankruptcy proceedings. In some cases, this is a standard in which that's used. So I guess what is the difference for an educator expected to meet this standard? One of the critiques we had of both provisions in HB 10 and in Senate Bill 430 was this seems to bypass the usual process by which a staff member or an educator, if there was a question that came in that they weren't sure about, that they could go to their principal or supervisor and seek guidance through there. I mean, but this is a very hard 10 business days. And so there's a concern there. The other one is, who is the arbiter of material information on whether an inquiry was answered completely or not. The honestly and completely standard in that hearing from a couple of years ago was pointed out by the attorney from the department that this was unclear and seems subjective and would be difficult to enforce. So that sort of goes to my point about what's the difference and why is this necessary, and the inclusion of this in the code of conduct. There's nothing in here about what if an educator forgets to include something that arguably should have been in an educator's written response. And so there's little leeway in here for an educator trying to meet the standard that this proposes. Seems to be very absolute in the way it's written. So with that, I'll close my testimony and happy to try and take any questions.
Thank you. Questions? Senator Abbas?
Thank you, Madam Chair, and thank you for taking my question. The underlying policy aside, the complete and honest response. Why is there, I guess, a lack of confidence that an educator would not be able to determine their response is complete and honest? I mean, part of their job, they grade assignments and answers to questions that they put in assignments. And I feel like they would be able to tell a complete answer from an incomplete answer. And I would hope they can tell they're being honest when they provide an answer.
Yeah, and I think honesty is something that's very important, especially when you're talking about the relationship between a teacher and a parent. I think I would answer your question with the question of what is the difference between that and the current law. I mean, this doesn't seem to say to the best of their knowledge or anything. I mean, if you forget something, is there a leeway here in this law for that to be acknowledged? I mean, at least as it's written, I don't see that. So I don't disagree with you about educators certainly are honest, and so what I think we would ask of this is this doesn't seem to allow for any room for an educator to make a mistake, to forget something. If that's the case, they're held to this completely honesty standard.
Thank you.
Yeah, but I'm not disputing your point about, you know, it's an important component of that relationship, to be honest with parents.
Any other questions? Seeing none. Senator Altshuler?
Thank you. So we've heard a lot of hypotheticals. And so let me put a hypothetical out there. If a parent is concerned that their child is having a relationship with another child and wants confirmation from the teacher that they're aware of this, now that's implicated a second student, correct? So is the teacher breaking confidences or possibly endangering a second student by answering a written answer within 10 days, of course, completely and honestly, that they are aware that the student whose parents have written to them is in a relationship with this other student, which the teacher has been apprised by the student that their parents would not be in favor of. And so now the teacher is in the position of having to expose information that may not be a physical danger to that child, but also entangles a second child into a situation for which they have nothing to do with these parents. So we have two kids, one has disclosed a relationship, or it comes about in passing and a parent needs to know. So they write a request, is my student involved with this student in a relationship? And now the teacher is obliged to answer within 10 days in writing, and now could possibly implicate another student in what could be a very sticky situation, or you know, very uncomfortable for everyone. Is that what this bill is going to end up doing?
Well,
We're going to get involved with, you know, the dating lives of teenagers?
I think this goes to the concern that was raised earlier about the difficult position that this could potentially put an educator in competing, trying to juggle and compete different interests, and also then, as I mentioned earlier, about determining what is material and then what is a complete answer, and whether too much details does violate either a situation like that or some other state or federal law where complete disclosure might risk a student's safety or create another situation. So I think that was raised earlier. I think it potentially does put an educator in a difficult position.
Any other questions? Seeing none, thank you very much.
Thank you.
That concludes the people who have signed up to speak. Is there anybody in the audience who would like to speak to this bill? Anyone? If not, this closes the hearing. Senate Education Committee.